My name is Dana. I'm 32, and I'm standing in front of a house I grew up in, the house where I learned to ride a bike on the driveway, where my grandmother braided my hair at the kitchen table, where I spent 18 years, and there is a family I have never seen before living inside it. There is a minivan in the driveway. There are different curtains in the window. The flower bed my grandmother planted along the front walk has been dug up and replaced with decorative gravel. I am holding a copy of my grandmother's will. I am holding a copy of the property transfer record I pulled from the county assessor's website at 11 o'clock last night. And I am holding the business card of the attorney I called this morning at 8 a.m. the moment her office opened. My parents sold this house 8 months ago. They never told me. The will said they couldn't do it without me. They had no idea I was already 3 steps ahead of where they thought I was. Before I take you back to where this started, please take a moment to like this video and subscribe. Drop your location and local time in the comments. I always love knowing where you're listening from. Now let me take you back to 2 years before this morning. 2 years before I stood on that sidewalk, I was 30 years old and working as a records analyst at a county planning department, a job that required me to read land surveys, zoning maps, deed chains, and property transfer histories every single day. I sat at a desk that faced a window overlooking a parking lot, and I ate lunch at that desk 4 days out of 5, and I drove a 2009 Civic with 194,000 miles on it that I had named, privately and without apology, Gerald Jr., after my father, because it made a lot of noise and never quite did what I needed it to. I am telling you about my job because it matters. What I do for a living is read property records. I know how title transfers work. I know what a deed of sale looks like. I know how to pull a chain of ownership going back 40 years from a county assessor's website in under 6 minutes. My parents did not know this would matter. They should have. My name is Dana. I am the only child of Lorraine and Gerald Marsh, of a small town in the middle of the state where everyone knows everyone, and the courthouse has been the same building since 1923. I grew up in a house on Sycamore Street, 3 bedrooms, a covered porch, a backyard with a persimmon tree that my grandmother said had been there longer than the house itself. My grandmother, my mother's mother, whose name was Estelle, had owned that house. She had bought it with my grandfather in 1969, the year they married. And she had stayed in it after he died in 1998, and she had stayed in it through every year of my childhood, and she had been the fixed point around which everything else in my life orbited. Estelle was a small woman with enormous opinions and very clean windows. She washed them herself, every spring and every fall, from a stepladder she had owned since 1974. She made biscuits from memory, no recipe, no measuring cups, just her hands and the particular angle of morning light she said told her when the dough was right. She smelled like flour and ivory soap and something underneath that was just her, something I have never been able to name. She read to me on the porch in the summers, long books, unhurried, 1 chapter at a time. When I was 17, Estelle sat me down at the kitchen table and told me she had updated her will. She said she wanted me to know that the house on Sycamore Street would pass to my mother and to me jointly when she was gone. She said, "This house belongs to this family. I want you to have a piece of it." She put her hand on mine. Her hands were dry and warm. Always warm, and she said, "Don't let anyone take that from you." I was 17. I said, "Grandma, you're not going anywhere." She said, "I know. But now you know too." I have thought about that conversation many times in the past 2 years, the particular weight of it. The way she looked at me when she said it, direct and serious and very clear, the way she was about everything that mattered. I think she knew even then, something about my mother that I was still too young to see clearly. My mother's name is Lorraine. She is a woman of considerable surface warmth and considerable interior calculation, and for most of my childhood I could not tell the difference between the two. She made my school lunches. She came to every recital. She was the room mother twice. She organized the church Christmas drive and ran the bake table at the school fair and remembered the names of all my teachers going back to kindergarten. She was also, and I understood this only slowly, the way you understand the shape of something only after you have moved far enough away from it, a woman who made decisions that benefited Lorraine and then constructed explanations that made them sound like they benefited everyone else. My father Gerald is a gentle, ineffective man who loves my mother completely and has never, in my memory, offered a meaningful counterweight to anything she decided. He is not cruel. He is not calculating. He is the human equivalent of a door left ajar, present enough to provide cover, not present enough to change anything. He once drove 4 hours to help me move apartments. He carried every box. He assembled a bookshelf from instructions written in 4 languages and made it work. He bought me dinner after and left before 9 p.m. because my mother was waiting. That is Gerald, exactly. I moved to the city for work when I was 24. I came home for Thanksgiving and Christmas and my grandmother's birthday in April. I called Estelle every Sunday without fail, the same time, the same ritual, the same update on the persimmon tree, which she monitored with the seriousness of a small agricultural enterprise. My grandmother died in March of the year I turned 30, a Tuesday morning, in her own bed, in the house on Sycamore Street, which is exactly how she had wanted it. I drove 4 hours to be there. I sat with her at the end. I held her hand dry and warm right until it wasn't. The funeral was on a Friday. 43 people came. My mother organized everything and organized it well, and I want to give her that. Whatever else she did, she gave Estelle a proper funeral, and I have not forgotten it. What I did not know, standing at the reception in the church hall afterward with a plate of food I wasn't eating, was that my mother had already begun planning what came next. I met Helen at the reception. She was a neighbor. She lived 2 doors down from Estelle's house on Sycamore Street and had known my grandmother for 22 years. She was a retired probate paralegal, 60 years old, with silver hair cut short and a kind of handshake that tells you exactly who you are dealing with in the first 3 seconds. She had brought a casserole and a card. She found me in the corner and said, "Your grandmother talked about you every week. She was very proud of you." I said, "She talked about you too. You helped her with some paperwork a few years back." Helen said, "I did. She was a thorough woman. She wanted everything in order." I said, "She was." Helen looked at me for a moment. Then she said, "If you ever have questions about the estate, about how things are meant to work, I'm 2 doors down." I filed that away. I didn't know yet that I would need it. I would. The first sign that something was wrong came 6 weeks after the funeral. My mother called me, not unusual. She called every week or two and mentioned, casually, that she and my father had been talking to someone about the house. I asked what she meant. She said a local realtor had reached out, just an informal conversation, just to understand what the property might be worth in today's market. She said it quickly, lightly, the way she said things she didn't want me to examine too closely. I said, "Mom, the house is mine and yours jointly." "That's what Graham's will says." She said, "I know that, Dana. I'm just saying we had a conversation. Nothing is happening." I said, "Okay." I hung up. I sat at my desk and looked at the parking lot. I thought, she said nothing is happening as if something might be. I opened a new document on my computer. I titled it, Sycamore Street Notes. I wrote the date and what she had said word for word, as exactly as I could remember. That was the first entry. The calls continued over the following months. Never alarming on their own. Each one just slightly off, a word here, a vagueness there, the particular quality of my mother's voice when she was managing information rather than sharing it. Month 2 after the funeral. My mother mentions that she has spoken to the estate attorney, Gerald Hartley, who had handled my grandmother's affairs for 20 years, about next steps with the property. I ask what next steps means. She says there are some administrative things to sort out, transfer of utilities, insurance, the usual. I say, has the will been filed with the probate court yet? She says, I think so. I believe Gerald is handling that. Her answer is smooth and slightly evasive in the way that only sounds evasive if you are listening for it. I write it down. Month 3, I call Gerald Hartley's office myself. I identify myself as a named heir in Estelle Marsh's estate. The assistant confirms the will has been filed. I request a copy. It arrives 11 days later. I write it at my kitchen table on a Saturday morning with coffee going cold beside me. The language is clear. The house at 412 Sycamore Street is bequeathed jointly to Lorraine Marsh and Dana Marsh in equal shares, with a specific clause written in Estelle's hand, I would later learn, insisted upon, drafted over the attorney's mild suggestion that it was unusual, stating that the property may not be sold, transferred, or encumbered without the written consent of both named heirs. Both. Not one. Both. I read that clause 3 times. Then I drove 2 hours home to Sycamore Street on a Sunday, and I stood on the porch and I looked at the house and I thought about my grandmother washing the windows from a stepladder in 1974, and I thought she knew. She wrote that clause because she knew. I knocked on Helen's door. She answered in a cardigan, reading glasses on her nose, a book in her hand. She looked at me. She said, "Come in." I sat at her kitchen table and I told her about the call with my mother, the realtor conversation, the administrative vagueness. She listened without interrupting. When I finished, she said, "Did you get a copy of the will?" I said, "Yes, I have it with me." She read it, slowly, She got to the clause and she read it twice. Then she set it down. She said, "Your grandmother wrote this in specifically." I said, "I know," she said, "which means she anticipated someone would try to sell without you." I said nothing. Helen said, "Have you pulled the property record recently?" I said, "No, not since I got the will." She said, "Pull it tonight. Before you drive back." I pulled it on my phone in her driveway. The record was clean, Estelle Marsh listed as owner, estate pending, nothing unusual. I wrote it down anyway. Property record, clean as of today. Month 5. My mother calls with a new development. The house needs work, she says. The roof has a soft spot, the furnace is old, the back porch has rot along the baseboards. She says the cost of maintaining it is more than she and my father can manage on their own. I say, I can contribute to maintenance costs. What are we looking at? She gives me a vague number, several thousand at least, and says she get quotes and send them to me. The quotes never come. I write, maintenance conversation, no follow-up, no quotes sent. Month 7. My mother mentions in passing that she has been in touch with a buyer. I stop. I say, "Mom, we talked about this. The will requires my consent for any sale." She says, "Dana, this is a practical situation. The house is expensive to keep. A buyer has made a very fair offer." Her voice has changed. The warmth is still there on the surface, but underneath it is something harder. She says, "I would think you'd want to be practical about this." I say, "I want to see the offer in writing." She says she send it. She does not send it. I call Helen that night. I tell her about the buyer. Helen is quiet for a moment. Then she says, "Pull the property record again." I pull it right then, on the phone with her. The record is still clean. Helen says, "Pull it every 2 weeks. Set a reminder." I set the reminder. Month 8. I am at my desk at the county planning department on a Tuesday afternoon, eating lunch. Reminder goes off on my phone. I pull the Sycamore Street property record from the county assessor's site. 47 seconds. The record has changed. The property has transferred. Sale date, 11 days ago. Sale price, $287,000. Buyer, a family I have never heard of. Seller listed as Lorraine Marsh, only Lorraine. Not Dana. I looked at my screen. The fluorescent light above my desk buzzed. Someone in the next cubicle was on a call. A printer down the hall was running. I sat very still. Then I opened a new tab. I pulled the deed of sale from the document archive. My job gave me access to the full county record system. The deed was there, transfer recorded and filed. Lorraine Marsh, sole seller. A notarized signature. A closing date of 11 days ago. I looked at the deed for a long time. Then I looked at the clause in my grandmother's will, which I had photographed on my phone and kept in a folder I had labeled since the first day I filed anything about Sycamore Street-evidence. The clause was clear, both heirs. Written consent required. Both. My mother has sold the house. Without me, without my knowledge, without my consent. For $287,000. I did not react, not visibly. I closed both tabs. I finished my lunch. I sat at my desk until 5 p.m., and I did the work in front of me with the same attention I always gave it. But behind my eyes, something had gone very quiet and very clear. I drove home. I made dinner. I sat at the table. Then I called Helen. She picked up on the second ring. I said, "It happened." There was a pause, not of surprise, of readiness. She said, "I'll put the kettle on. Come over Saturday." Quick pause here. If you've ever been the person who kept everything running while everyone else took credit, you know exactly what this feels like. If that's you, hit subscribe. I share stories like this every week. Now, back to where things were about to fall apart. That Tuesday night, after I called Helen, I sat at my kitchen table for a long time. The apartment was quiet. A neighbor's television was audible through the wall, faint, indistinct, someone else's evening. My own dinner plate was still in front of me, half finished. I looked at it. I looked at the window, ground floor, facing a courtyard, the kind of view that is neither interesting nor unpleasant. Just outside. I was not crying. I want to say that precisely because I think people expect a moment like this to break open in a particular way. It didn't. What I felt was the physical sensation of something settling, the way a structure sounds when the last piece is put in place. A click. A finality. Not grief yet. That would come later, in smaller pieces, over longer time. Right now what I felt was resolution. The thing I had been watching for had happened. Now I knew what I was working with. I opened my laptop. I opened the evidence folder. It had 12 entries, the call about the realtor, the administrative vagueness, the maintenance conversation with no follow-up, the buyer mention with no written offer, the bi-weekly property record checks with dates and results. And now, the transfer record, the deed of sale, the date, the price. $287,000, sold. Without me. I added a new entry. I wrote the date. I wrote, property transferred 11 days ago. Lorraine Marsh listed as sole seller. Dana Marsh not listed. No consent obtained. No notification given. Proceeds unknown. Then I opened a new subfolder. I named it Legal. I went to the county assessor archive and I downloaded the full deed of sale, all 4 pages, and saved it to the folder. I downloaded the transfer record. I downloaded the probate filing for my grandmother's estate, which I had bookmarked months earlier. I copied in my photograph of the will clause. I looked at what I had assembled. I am a records analyst. This is what I do. I ride the chain of title. I follow the document trail. And what the document trail said plainly was this. My mother has sold a property she did not have the sole legal right to sell, using only her own signature without obtaining the written consent of the co-heir named in the controlling document, the will of the original owner, which had been filed with and accepted by the probate court. In plain language, she has sold something that was half mine without telling me, without asking me, and without giving me any part of the $287,000 she received for it. I sat with that for a while. Then I thought about Estelle, the kitchen table. Her dry warm hand on mine. Don't let anyone take that from you. And I thought, she knew. She wrote the clause because she knew exactly what her daughter was capable of. She tried to protect me. And my mother had found a way around it anyway. I felt something then, not anger, not yet. Something closer to grief and clarity at the same time. A composite feeling that had no single name. I closed the laptop. I got up. I washed my plate. I folded the dish towel. I looked at the courtyard window for a moment. Then I went to bed and I did not sleep for a long time. Saturday morning I drove to Sycamore Street. I did not plan to stop in front of the house, but I did. I pulled over across the street and I sat in the Civic with the engine running and I looked at it. Different curtains. Decorative gravel where the flower bed had been. A minivan in the driveway. A child's bicycle propped against the porch railing. The persimmon tree was still there. In the backyard, invisible from the street, but I knew it was there. I sat for 4 minutes. Then I drove to Helen's. She had the kettle already on. The table was clear. She had her reading glasses and a legal pad, and she had clearly been thinking about this since Tuesday. I put the folder on the table. She said, "Show me the deed." I showed her everything. The deed, the will clause, the transfer record, the probate filing, the 12 entries in the notes document, printed and dated. She read it all without speaking. When she finished, she took off her reading glasses and set them on the table and looked at me. She said 3 words. She had no right. Not, "This looks complicated." Not, "Let's see what the options are." She had no right. I said, "I know," she said. "You need a probate litigation attorney. Not a general estate lawyer. Someone who handles contested transfers." She turned to the legal pad. She wrote a name, Frances Okafor, at a firm called Okafor & Bell. She said, "I worked alongside her years ago. She is exact. She does not lose paperwork cases." She slid the legal pad across to me. She said, "Call Monday morning, before you do anything else." "Before you call your mother?" I said. "I haven't called my mother yet." She said, "Good, don't." I folded the paper and put it in my jacket pocket. I sat there for another hour. We drank tea. She told me about a case she had worked, years ago, involving a similar clause in a family estate. She told me what had held up in court and what hadn't. She was precise and calm, and she spoke the way she always spoke, as if the facts were the only thing that mattered and emotions were a separate lane that did not need to merge with this one right now. When I left, I sat in the car and looked at Sycamore Street through the windshield. Then I drove back to the city. Monday morning, 8:03 a.m., I called Frances Okafor's office. Frances Okafor's office was on the 3rd floor of a building that smelled like wood polish and central heating. She was in her early 50s, a tall woman with natural hair pinned up and reading glasses that she did not misplace, ever, because they were always exactly where she put them. She read my folder in 26 minutes. She asked 11 questions. Every question had a documented answer because I had been documenting for 9 months. At the end, she set the folder down. She said, "You're a records analyst." I said, "County Planning Department. Property records, deed chains, Title transfers, she said. So you understand what you have? I said. I understand that my mother sold a jointly owned property using only her own signature, in violation of an explicit will clause requiring written consent of both heirs, and that I have the probate filing, the will, the deed, the transfer record, and 9 months of dated notes documenting the pattern leading up to it. Frances looked at me for a moment. She said, yes, that is what you have. She told me what was possible. In our state, a property transfer that violates the terms of a controlling probate document, specifically, a will clause requiring joint consent, is a voidable transaction. Not automatically voidable, meaning, a court can undo it, or can award the injured heir their rightful share of the proceeds, depending on circumstances and timing. The house had been sold 8 months ago. The new family was living in it. Voiding the sale entirely was unlikely and would harm people who had done nothing wrong. But the proceeds, $287,000, had been received by my mother. Half of that was mine. $143,500. Plus, under the specific statute Frances cited, damages for the violation of the probate clause, which in contested cases could include attorney's fees and additional compensation. She said, your mother will likely claim she misunderstood the clause, or that she believed she had your implicit consent, or that she tried to reach you and couldn't. I said, I have records of every conversation, every call, every message, including the ones where she specifically told me nothing was happening, and the ones where she refused to show me the written offer. Frances said. Good. She paused. She said, there's one more thing I'd like to know. Your aunt, your mother's sister. Do you have a relationship with her? Ruth, my mother's younger sister. I had not spoken to her since the funeral, but we were cordial. She had always been the quieter, steadier one of the two sisters, the one who sent cards on time and did not involve herself in other people's decisions unless asked. I said, she was close to my grandmother. She came to the funeral, Frances said. Do you know if she was aware of the sale? I said, I don't know. Frances said, it might be worth a conversation. Not to pull her into this as a witness, just to understand what she knows. I called Ruth that weekend. I told her what I had found. There was a long silence on the phone. She said, Dana, just my name. The way someone says a name when they are holding something they have been holding for a while and aren't sure yet whether to put it down. Then she said, your grandmother asked me to check on you after she was gone. She said, Ruth paused. She said your mother sometimes doesn't know where her wants end and other people's rights begin. I said, did you know about the sale? Another pause, shorter. She said, Lorraine told me the house has sold. She said you had agreed. She said it was settled. I said, I didn't agree. I didn't know. Ruth said nothing for a moment. Then she said, I read the will after the funeral. I knew what it said. She said it quietly. The way someone says something that has been sitting in them and finally needs to come out. She said, what do you need from me? What my mother did not know, what she had never known, because she had managed this the way she managed everything, with the confidence of someone who has always decided the outcome in advance, was what I was holding. She did not know about Frances Okafor. She did not know about the legal subfolder. She did not know that I had pulled the deed of sale from the county archive using my own professional access on the same Tuesday afternoon the reminder went off on my phone. She did not know that Helen had been 2 doors down from her mother's house for 9 months, reading glasses on, legal pad ready. She did not know that Ruth had read the will and remembered what it said. She did not know that I had, in a manila folder on Frances's desk, a complete documented chain of everything she had done, dated, organized, sourced, assembled by a woman whose entire professional life had trained her to read exactly this kind of record. What she knew was that she had sold the house, that the check had cleared, that $287,000 had moved in the direction she had intended. What she did not know was that I was already moving in her direction. Alright, I need to pause here for just a second because this next part I've never told anyone the full version. If you're still here, thank you. That means something. Hit subscribe so you don't miss what comes next. And drop a comment. What would you have done? Okay, here's what happened. Frances filed a petition with the probate court on a Thursday morning. The petition named my mother as the respondent in a contested estate proceeding, citing the unauthorized transfer of jointly held property in violation of the controlling will clause. It requested an accounting of the sale proceeds and damages, including my rightful half share of $143,500 plus applicable statutory penalties. She had my mother served on a Friday afternoon. My mother called me at 4:47 that Friday. I let it ring. She called again at 5:03, and at 5:31, and at 6:14. At 7:02 she sent a text. It said, "Dana, please call me. I don't understand what this is." I read it. I put the phone down. I had agreed with Francis that I would not speak to my mother outside of any formal proceeding until the petition had been acknowledged and her attorney had entered an appearance. Francis had been clear. Anything said in an informal conversation before counsel was involved could be used to muddy the record. I had agreed. I was disciplined about it. My father called at 8:15. I let it ring. I sat in my apartment in the quiet and I looked at the courtyard window and I thought about my grandmother's kitchen table and the feeling of her hand on mine, and I let myself feel briefly the weight of all of it. The house that was gone, the curtains I didn't recognize, the gravel where the flower bed had been. I let it sit, then I set it aside. I had work to do. The formal response hearing was scheduled 6 weeks later. It was not a full trial, a preliminary proceeding before a probate judge to establish the facts of the estate, the terms of the will, and the circumstances of the sale. My mother had retained an attorney, a local man named Dennis Pryor, who had practiced in that county for 30 years and knew everyone and was not, based on Francis's assessment, particularly experienced in contested probate matters. The hearing was on a Tuesday morning. The courthouse smelled exactly as it had every time. I had driven past it for 30 years, old stone, and something faintly metallic, the particular smell of institutional permanence. I arrived with Francis. We sat at one table. My mother and Dennis Pryor sat at the other. My father sat in the gallery. He had not been named in the petition, as the property had been in my grandmother's name, and his role was peripheral. He sat in the second row with his hands on his knees, and he did not look at me. My mother looked at me once when she came in. Her face was composed, posture correct, the particular surface warmth in its usual position, deployed now in the direction of the judge's bench like a form of armor. She was wearing the same perfume she had worn my whole life, something clean and floral. The smell of my childhood. I kept my hands flat on the table. The judge, a woman in her 60s with reading glasses and the expression of someone who has heard every variation of every family dispute and is not surprised by any of them, called the proceeding to order. Francis presented the petition. She laid it out in exactly the order we had organized it: the will, the probate filing, the clause, the property transfer record, the deed of sale, the dated documentation of the pattern of conversations in which my mother had actively withheld information about the sale while leading me to believe nothing was happening. Dennis Pryor argued that my mother had believed she had implicit consent, that the conversations between us had indicated my general agreement to a sale at some point, and that the clause in the will had been an informal expression of intent rather than a binding legal requirement. Francis said, without raising her voice, "The clause is written in explicit legal language, drafted by counsel, filed with the probate court, and accepted as part of the estate record. It requires written consent from both named heirs. No written consent was obtained. No attempt to obtain written consent was documented. In fact, the opposing party actively withheld information about the sale from my client during the period in which it was being negotiated and completed." The judge looked at Dennis Pryor. Dennis Pryor said, "My client believed in good faith." The judge said, "Does your client have any documentation of an attempt to obtain written consent from the co-heir prior to the sale?" Dennis said, "We have records of conversations." The judge said, "Written consent, as specified in the will clause." There was a silence. My mother's face did not change. But something in her posture shifted, the smallest possible adjustment, barely visible, the physical equivalent of a position becoming less tenable. My father, in the gallery, was looking at the floor. Francis said, "Your Honor, we have dated documentation of 9 months of conversations between my client and the respondent, including specific instances in which the respondent stated no sale was occurring while simultaneously engaging in sale negotiations. We have the deed of sale bearing only the respondent's signature, and we have the will clause, which could not be more explicit." The judge looked at the documents. She read slowly. She turned to the will clause. She read it twice. Then she set the documents down. She said, "The clause is explicit. The transfer documentation confirms a sale conducted without the co-heir's knowledge or written consent. This proceeding will move forward." She scheduled the full hearing for 8 weeks out. My mother stood when the judge rose. She and Dennis Pryor spoke in low voices. I did not look at them. Francis collected our papers. As we walked out, my mother said my name. I stopped. I turned. She looked at me. For a moment the surface warmth was gone entirely, and what was underneath it was something I recognized, something that had always been there, that I had spent 32 years interpreting as love, and only recently understood was something more complicated than love. Something that included love and also included the absolute certainty that her wants outranked other people's rights. She said, "I did this for the family." I looked at her. I said, "Grandma wrote the clause for the family too." I turned and walked down the courthouse steps with Francis. Outside, the October air was cold and clean and smelled like fallen leaves and concrete. My father was on the steps above me. I heard him say, quietly to no one in particular, "Dana," just my name. I did not stop. I sat in the Civic in the parking lot for 7 minutes. My hands were shaking, not from fear, from the effort of having been completely still in that room for 2 hours. I let them shake until they stopped. Then I called Helen. She picked up on the first ring. I said, "The judge is moving it forward." Helen said, "I know she would." I said, "How did you know?" She said, "Because the clause is explicit and you had everything documented." A pause. "Your grandmother knew what she was writing." I sat there for a moment. I said, "Yes, she did." The full hearing was 8 weeks later. I will not walk you through every detail because what matters is the outcome. The probate court found that the sale of the property at 412 Sycamore Street had been executed in violation of the will clause requiring written consent of both named heirs. The transfer was not voided. The new family had purchased in good faith and could not be displaced, but the proceeds were subject to a full accounting. My mother had received $287,000 from the sale. Half of that, $143,500, was ordered distributed to me as the injured co-heir. The court also assessed a statutory penalty for the probate clause violation, an additional $18,400. Attorney's fees were ordered paid by the respondent. My mother paid, not gracefully, but she paid. My father called me 3 weeks after the judgment. He said he wanted me to know he had not known the full situation until the petition was filed. He said, "I knew about the sale. I didn't know about the clause," or, he paused. I didn't ask. He said those 2 words the way a man says something he has been carrying for a long time. I didn't ask. I said, "I know, Dad." He said, "I'm sorry, Dana." I said, "I know." We did not talk long. But we have talked since. Carefully, slowly, in the way that things rebuild when the ground has shifted, not the same ground, not the same structure, but something. My mother has not called me. I do not expect her to. Ruth called me the week after the judgment. She said, "She's angry at you." A pause. "But she knows." I said, "What does she know?" Ruth said, "That your grandmother was right." Helen and I had coffee the Saturday after the judgment finalized. She brought biscuits, store-bought, she said, with the particular candor of a woman who does not pretend. We sat at her kitchen table on Sycamore Street, 2 doors down from the house where I had grown up, and we drank coffee and ate biscuits and did not say a great deal. At some point she said, "Your grandmother would be glad." I said, "I think she wrote the clause knowing this might happen. And knowing I would find it." Helen said, "She knew who you were." I thought about that for a long time. With the settlement, I did something I had been thinking about for years. I put a down payment on a small house, not Sycamore Street, not my hometown, but a place of my own. A 2nd-floor unit with a kitchen that faces east. In the mornings, the light comes in across the table at an angle that makes everything look deliberate. I bought a small persimmon tree at a nursery and put it in a pot on the back porch. It is not Estelle's persimmon tree, but it is mine. I have been asked what I learned from this. The truest answer is something I already knew and had to relearn. Documents tell the truth. People tell stories. And when the story and the document disagree, you trust the document. My grandmother understood this. She didn't leave her wishes in a conversation or a promise or a verbal understanding. She sat with an attorney and she used exact language and she filed it with a court and she created a record that survived her death and my mother's plans and 2 years of careful misdirection. She built something that held. I spent 9 months doing the same thing, not because I am extraordinary, but because I was paying attention and I wrote it down. Every call, every evasion, every bi-weekly property record check, every entry in a folder I titled evidence. When the moment came to use what I had, it was there, organized, dated, complete. What I know about Lorraine is that she loved me in her own way and also sold something that was half mine without a word. Both of those things are true. I have stopped trying to reconcile them into one coherent portrait. Some people contain compartments that don't communicate with each other. The compartment that loved me and the compartment that signed that deed of sale existed in the same woman. I cannot explain it. I have stopped needing to. Helen is still on Sycamore Street, 2 doors down from the house with the new curtains and the decorative gravel. She texts me occasionally. Last spring she sent a photo of the flower bed. The new family had replanted it. Tulips, she said. Different from what Estelle had. But flowers. My life now is more mine than it has ever been. I still drive the Civic minus 211,000 miles now, still making noise, still getting me where I need to go. I still eat lunch at my desk most days. I still read deed chains and property records for a living, which strikes me sometimes as the most fitting thing I could possibly be doing. Here's what I want to say to anyone listening who has a document they haven't read yet, or a clause they've been told doesn't matter, or a conversation they haven't written down. Read the document. Read it again. Write down the conversation. Date it. Keep it somewhere you control. The people who benefit from your inattention are counting on you not to do this. Do it anyway. That's Dania's story. Or maybe in some way, it's yours too. If you've ever been the one holding everything together while everyone else let go, I see you. Drop your story in the comments. I read every single one. And if this meant something to you, subscribe. There are more stories in the description. Women who decided enough was enough and did something about it. I'll see you in the next one.